further to my arguments which I had made on the last occasion. And in order to establish that these witnesses who have been shown as eyewitnesses are actually not persons on whom implicit reliance can be placed, I would like to draw your lordship's attention to their evidence first. Now, before your lordship goes to their evidence, it must be remembered, my lords, that all these three witnesses are not natural witnesses. Rather, they are chance witnesses. PWs 1 and 5 being there because of having accompanied the deceased to marketing and returning with their purchases, and PW6 being there allegedly in the veranda of his brother-in-law. None of these three witnesses are witnesses of the locality. And they are all inimical and belong to the rival group of which the deceased was their leader, which they are. Now, in view of these submissions, that they are chance witnesses and belong to a village which is riven by party faction, where their leader has been murdered, your lordships have now to analyze their evidence with utmost care and caution. I don't say that merely because the witness is partisan is to be disbelieved, but the evidence of such witnesses has to be scanned and scrutinized with utmost care and caution. And if it is so scanned, my lords, my submission will be that these witnesses will be found not to be witnesses to truth, but got up witnesses. And the reason for my making such submissions is, firstly, the fact that PWs 1 and 6, besides being members of the hostile part of one party, PW6 is a relation of the deceased, close relation. Sorry, PW5 is a close relation of the deceased. So far as 6 is concerned, my lords, 6's deposition, my lords, is suspect because of his silence for about 4 days without disclosing the incident to anybody. And secondly, fact remains, my lords, that the IO went first, my lords, to the place where these witnesses reside instead of going to the spot, got the FIR recorded there, then came back to the spot and effected seizures. And who are the witnesses to the seizures? They are none else than PWs 1 and Exhibit 1, 2, 3, 4. They are all witnesses to seizures are none else than PWs 1 and 5. Now, may I draw your lordship's attention to the evidence of PW1?
You place the relevant portion.
Yes, I am placing the
It has
relevant.
already been placed clearly.
Now, at paragraph 2, in the 4th line, he says, we returned to the village at 6 p.m. Bhagirathi was riding one cycle. I was riding another cycle. Prafulla was pillion rider in my cycle. I was coming ahead of Bhagirathi. Then he says, after one sentence, that I accused Subala, who was carrying a grocery shop in a wooden cabin in front of his house. I found a gathering there. Ranka, Subala, Madhava, Dondu, Kalu alias Duryodhan were standing in front of the shop. Now he doesn't say that either these persons were standing being armed nor he says that they were making any threatening gestures. He says that I crossed them. Thereafter, Bhagirathi passed. While passing them, Ronko suddenly dealt a farsa blow on the back of Bhagirathi. At this, Bhagirathi ran away to a little distance, throwing his cycle there. Your Lordship, may mark this one. Then he says, Madhu Pradhan, Ladukar, and Bidhubhushan Patnaik obstructed him at a little distance. So Bhagirathi could not proceed further in any direction. He fell down there. Accused Ronko assaulted deceased by means of a farsa on his left ear, which was half severed from its place. Again says, when aforesaid three accused obstructed Bhagirathi, Ronko came and dealt a farsa blow on his left ear, and so he fell down on the ground. Then he describes the weapons which these accused were holding, and he implicates Ronko, Subala, Dandu, Madhava, Vidhubhushana, Ladu, and Ladu Pradhan as having dealt farsa blows on the deceased. Now, your Lordship may look at paragraph 5, my Lord, with regard to seizure of the chappal and the wristwatch. He says that the chappal belonged to me and the wristwatch belonged to Bhagirathi. I can identify if the same is produced in court. They have been marked MOs 1 and 2. Then he says that 2 live bombs were seized in front of the house of Kirtan. Kirtan is not an accused. It's nobody's case, my lords, that these bombs were either used by Kirtan or they were thrown by any of these accused here. So this seizure has no importance at all. Then he says, remnants of the bombs were seized from in front of the house of one Sambari Nayak, situated at a distance of 20 to 25 cubits from this. This, my lords, is important. The spot is not in front of the house of Sambari Nayak, which is at a distance of 20 to 25 cubits here. And remnants of these bombs have been seized from the house of somebody who is neither a witness nor an accused. This is why Exhibit 4. Now, my lords, come to the paragraph 8 of his proceedings, 2 lines. The band of the wristwatch is not a complete one and in good condition. A part of its locking arrangements missing from the band. Police seized the MO1 in this present condition. Missing portion was not searched by the police. I cannot say the whereabouts of the other chappal out of that pair. The chappal belongs to him, but he cannot say the whereabouts of the other chappal. Then your lordship may straight away come to paragraphs 14 and 16 in Prosecution. No, your lordship may look at paragraph 13. I was present when Prafulla Karo gave statement to the police. It is not a fact that none of the accused had assaulted Bhagirathi on that day. It is also not a fact that Bhagirathi had not received any injury before 7:30 p.m. So he admits that he was present when the statement of the PW6 was recorded.
PW5.
5, yes, I am sorry. Then my lords may see what he says with regard to this spot, my lords. This is paragraph 10, my lords. Village Sanagoroda consisting of 4 sahis. They are Puruna Sahi, Nua Sahi, Totta Sahi and Bilogoroda Sahi. Totta Sahi and another 3 sahis are intervened by river Kusumi. house of the deceased Bhagirathi situates in Totasani. Now here I'll ask my lords to kindly look at this spot map again. As per the spot map, the house of Bhagirathi is shown in the spot map to the west of the road Millards and across the river Millard. And all these witnesses also belong to that same area. Our village situates to the eastern direction of Saranpur. If one would come from Saranpur to my village, he would pass through Puruna Sai. The last extreme house to the east of Puruna Sai belonged to Gopala Patnaik. Thereafter, there is a threshing floor of different persons of my Sahi. After the threshing floor, the houses of Nuasahi people situates. All the accused belong to Nuasahi. All witnesses of this case, except official witnesses, are of my Sahi. Now, your lordship may see, though the incident has happened at Nuasahi Millards, there is no local witness of Nuasahi. And the witnesses in this case, Millards, they all belong to Totasai, including the two Caesar witnesses, PWs 2 and 3, PWs 1, 5 and 6, as well as PW 4, who is the author of this station diary number 507. Then,
This deceased belong to Nuasai.
yes, belong to Totasai. House of deceased Bhagirathi Karapra upare achu. Kusumi river ro upare.
Occurrence took place in Nuasai.
Occurrence took place in Nuasai.
Deceased Seju Aratare.
Aye.
And this man belongs to
Same place, Totasai.
ଲେଖା ହେଇଛି କଣ ମୌଜା ସାମ ଗୋରଡା PW1
ଆଜ୍ଞା ସେ ଅଛି ଏଭିଡେନ୍ସ ରେ ଅଛି ଧରିକି ଯେ ମୁଁ ସେଇଠି ଅଛି
in the Mahisai is lying at a distance of 300 yards from the spot. In the
the threshing floor ପଳେ କହିଛି
case except the official.
all witnesses of this case except official witnesses are of my side.
No, Mr. Panda, you are projecting these three witnesses are chance witnesses.
Yes.
Chance witnesses is a witness who is not ordinarily expected in that place.
Right.
By virtue of some incident or something like that.
Exactly.
His presence is so. He is giving an explanation, or you can in statement say that why I was there in that spot. The reason is that I had gone there to purchase groceries with the deceased was there in another cycle. So in that process, while we are coming in two cycles, and that is how our presence. So unless you discard that by way of cross-examination, that part is disbelieved, then it cannot be said that he is a totally stranger. He belongs to some other locality. Ordinarily, his presence would not have been expected there, and therefore he is a chance witness. But because his house is situated at a distance of just 300 cubic, he has stated in the cross-examination.
Yes, he has stated at a distance of 300 cubic.
Right.
But we must admit that it is beyond the river.
No, you see the river is, don't say that river is, maybe that what is the length of river.
No, it may be a rivulet,
so,
but it is beyond that.
the other side, it appears that the...
that I will try to explain to you. Lords, apart from cross-examination, I can also show through the evidence of the witnesses, discordant statements of the witnesses, my lords, that these people are witnesses who would not have been present there at that time when they are saying. That is what I intend to say. So therefore now, your lordship may see.
For example, let us say, take an example.
Yes.
A milkman belongs to, let us say, his house is 5 kilometers away from a spot.
Milord.
And ordinarily he comes every day morning to
Yes.
give milk in different houses in the spot village.
That's true.
So merely because his house is situated at a distance of 5 kilometers, you cannot say that he
We
is
cannot-
chance witness, because he's
I
giving an
agree.
explanation why I was there at that point of
I
time.
concede to what your
So here
lordship is
also this witness is giving that unless you say by evidence that no, this grocery theory
Aye.
is not believable.
Exactly.
Then
Exactly. That's what I want to say. Number one is that grocery theory is not believable. Number two is, milords, that their presence at the spot, that is what is shown in the spot map, near the house of this Narsingha Pradhan, that the assault took place, where they crossed the cabin of Subal Pradhan and proceeded towards the south. They would not have proceeded at all because their houses are beyond the river Kusi. There was no necessity of their coming here. This will be clear if we
Mr. Panda, unless you put the question that your house is at this place, why you had gone to there? So we are also asking you that unless you put the question, how can you expect an explanation? That's why I just gave you an example. Let us say you are coming to court from Pithapur every day.
Aye.
Suppose on a particular day you might be have some work in
Aye.
Bangla and you had gone there.
Aye.
So you saw some incident.
এই প্যারাগ্রাফরে পুরা ক্রস রে বাহারিছি মু প্লেস করছি এই প্যারাগ্রাফটা এই যে প্যারাগ্রাফটা মু প্লেস করছি বর্তমান প্যারাগ্রাফ 10 সেইটারে আছে I am placing from page 5 again, milords. That sentence begins after the threshing floor houses of Nuasai people situates.
Page 142.
Paragraph कितने number?
Page 1.
142 para 10 page 142 of the paper. Internal page 5. After the threshing floor, the houses of Nuasai people situates. All the accused belong to Nuasai. All witnesses of this case, except the official witnesses, are of my side. Godipada village is at a distance of 4 to 5 kilometers from my side. And say Joto Asuti. Prafulla purchased potato and banyan from Godipada market. It may be bananas or it may be onion. I'm not sure. Bhagirathi purchased tomato and potatoes from that market. He also purchased a packet of mixture, a packet of biscuits, and cow fodder. Now, I can understand, milords, purchase of these vegetables and root tubers, mixture, biscuits being carried in bags. Was he purchasing half a kilo of cow fodder? Did he purchase half a kilo of cow fodder?
No, what
I'm not again going to the fact that I admit I have not asked him in a cross-examination as to what was the quantity he put.
No, we are not on that. You are, unless you demolish, rather
Aye.
when you put the questions,
Say demolition को भी जाओ.
what you purchase, he has stated that
Aye.
whatever he has remembered at the time of giving
Yes,
evidence, he
Milord,
has
I
stated
agree.
that on that day we purchased like this.
Aye.
Ordinarily, it is not expected a man to remember after so much of time that what is the groceries purchased on a particular day. But since it is a specific day when this ghastly or the
Incident took place,
he might be
required to remember.
So he just remembers
Yes.
that, sir.
So now look at the next sentence, what he says. That he brought those articles in 2 bags. The Lordship may mark.
Yeah.
Then he says, I also purchased potato and brinjals a kg each. I saw the gathering from a distance of 20 to 25 cubits. It's not a fact that one can see the gathering in front of the shop of Subod from a distance of 700 to 800 cubits. Now, your Lordship may see. House of the accused Lodu situates at a distance of 300 to 400 cubits from the shop of Subod towards Godipada Sahi. There is a road leading to Totasai near the house of Lodukara. So there is a road leading to Totasai near the house of  By then, the riverbed of Kusumi was having little water. that was the shortest route to go to the house of Bhagirath. Now, if your lordship will look at the spot map, Milords, the house of Ladu is situated 300 to 400 cubits from the shop of Subala towards Godipada. That is towards the eastern extreme. From where they are coming. And there is a road leading to Totasahi near the house of Ladukara. And that is why intentionally the house of Ladukara is not shown in the map. Because it is beyond what is the cabin of Subala Pradhan towards the east. And the road leading to Totasai is near the house of Ladu, and that is the shortest distance to the house of the deceased. So why should these people come to the cabin of Subala? Why should they proceed from the cabin of Subala towards Saranapur? That is to the south Millards. That is where the incident will happen. And if that was the shortest route to the house of Bhagirathi, from the house of Ladu, crossing the Kusumi river, which had little water, what necessity was there for them to go in a roundabout way?
Who would have answered that? Who would have answered that? PW1 is the best witness.
You would have answered.
Have you put any question to that?
There again I am coming. If he says that that is the shortest way, Millards, am I required to put a question as to why you did not take the shortest way?
So that is exactly that. So a person would go in a particular route every day. Is it acceptable that he cannot go by any other route?
It is not.
It might be.
It is not. But then the question will be, why should somebody go by a Nuwa side where there is a dispute instead of taking the shortest route?
That could have been answered unless you put the question. You are drawing that, arguing that his presence at the spot when another route, shortest route is available to his house, why you would have taken this particular
The fact that I have put this question, that there is another route which is a shorter route, entitles me to argue, Millards, that he should have taken that route and he has not taken that route intentionally and no incident has happened here. The question is, has the incident happened here, will he say? That again is in doubt, Millards. Now kindly look at the next paragraph, what he says in cross-examination. There is a difference of opinion, dispute between the people of Purna side and the accused persons since 16/10/1990. Now, with regard to his statement in Chief Millards about having seen these people, appellants in this 139, standing near the shop of this Subala, again at paragraph 12, what he says is this: none of the persons assembled in front of Subala had tried to assault me or Prafulla when we passed through them. None of them had also used any obscene words to us. We had not expected any danger when we passed through them. It is not a fact that
because the target was Bhagirathi.
Exactly, Millards. We have not expected mane kon. See, we mane tin jananko katha kohuchi na.
He was coming a little behind.
Bhagirathi target age kothi habo?
The Aguru, just to think of it, while you are arguing, we are pointing out because you have to clarify our mind also. ଯଦି ଆଗରୁ ସେମାନେ ରାସ୍ତା ଉପରେ ମନେ କରନ୍ତୁ ବିଭିନ୍ନ ହାତ ହତିଆର ଦେଇକି ଛିଡା ହେଇଥାନ୍ତେ ତାହେଲେ ଯୋଉ ଲୋକଟା ଦୂରରୁ ଆସୁଛି ଅର୍ଥାତ ଭାଗୀରଥୀ ସିଏ ହୁଏତ ଦେଖିକି ପଳେଇ ଯାଇଥାନ୍ତେ. ଦ୍ୟାଟ୍ ଇଜ ହାଉ ଇଟ୍ ଇଜ ପସିବଲ ଦ୍ୟାଟ୍ when they allowed these men to pass through.
ସେଇଥିଲାଗି ପୁରା ଆଜ୍ଞା ମୁଁ କହୁଛି ଯେ ତିନି ଜଣଙ୍କର ଏଭିଡେନ୍ସ has to be read in consonance. PW6 ପୁରା କହୁଛି ମାନେ ଆର୍ମ ଦେଇକି ଛିଡା ହେଇଥିଲେ. PW6 ର ଏଭିଡେନ୍ସ କଣ? All these 5 people are standing holding arms.
The moment they passed.
No. What PW6 is saying that he is standing from the veranda of his brother-in-law. So he says that when I saw these people coming, I also saw these appellants standing holding arms. Then, your lordship may see, we had not expected any danger when we passed through them. It's not a fact that I have not stated to the police that Subala was also present there. Road leading from Godipada to our Sahi is north-south direction near Nuasai. Then, your lordship may see, after one sentence, I had already got down from my cycle when I first saw accused Ronko dealing a farsa blow on the back of Bhagirath. He is proceeding ahead, he was proceeding ahead along with PW6, and he says that it was the first blow was dealt on the back of Bhagirathi by Ronko. Lords, I can understand somebody having eyes behind his head to see what is happening.
This man was he was sitting behind at that.
No, this man was riding the cycle.
Where is that?
PW1, a pillion rider by informant.
Okay, pillion rider. This man was.
PW5 is pillion rider. So he has already got down from his cycle when he first saw Ronko dealing a farsa blow on the back of Bhagirath.
PW5 was pillion rider.
Yeah. Profula Kara PW5. Now, Jyoti Arya first blow hela on the back of Bhagirathi, who was proceeding behind these people. Ye cycle ru olhila beluku ye kemiti dekhila farsa blow ta poduchi boli. I heard his shout of being killed, of I being killed. On the first blow, Bhagirathi jumped from the cycle and started running. The cycle fell down there. Articles purchased by him lay scattered there. Mark this sentence also. ଗୋଟେ ଲୋକ ଆଗରେ ଯାଉଛି ସାଇକେଲ ଚଲେଇକି, ତା ପଛରେ ଆଉ ଜଣେ ଯାଉଛି, ପଛ ଲୋକକୁ ତା ପଛ ଆଡୁ ଆକ୍ରମଣ କରାହଉଛି। ଇଏ ଆଜ୍ଞା ଓହ୍ଲେଇ ପଡିକି ଭାଗୀରଥୀର ପାଟି ଶୁଣିକିରି ଏତେ ଜିନିଷ କେମିତି ଦେଖିଲା? Is it probable? And this sentence, your lordship may mark that the articles purchased by him lay scattered there. Because this has to be read in consonance with the production of the Atlas cycle on 9/7/1991, being produced by the father PW7, containing one bag having rotten vegetables. The cycle fell on the...
By there was standing at a distance. By then we were standing at a distance. 143. 143. Okay. I heard a shouting. The cycle was.
The cycle fell down there. Articles purchased by him lay scattered there. By then we were standing at a distance of 10 cubits from Bhagirathi towards the south. I stood holding my cycle. Profula stood near me. We remained standing there even though many persons chased after Bhagirathi, being armed with weapons. Now we have to correlate this, what he has stated, with his examination in chief. Now let us go back to the examination in chief for a moment, Millards. That is at page 139 of the paper book, my lords. Page 138, the last line, your lordship will see. Last three lines. Subala was carrying a grocery shop in a wooden cabin in front of his house. There I found a gathering. Ronko Nayak, Subala Pradhan, Madhav Pradhan, Dandu Pradhan, Kalu Pradhan alias Duryodhana were standing in front of Subala's shop. I crossed them. Thereafter, Bhagirathi passed. While passing them, Ronko suddenly dealt a farsa blow on the back of Bhagirathi. At this, Bhagirathi ran away to a little distance, throwing his cycle there. Madhu, Ladu and Vidhubhusana obstructed him at a little distance. Bhagirathi could not proceed further. He fell down there. Then Ronko assaulted, deceased by means of a farsa on his left ear, which was half severed from that place. Now, there is no injury on the left ear, my lords. Severing the injury. ତାପରେ କହିଲା indiscriminately ରଙ୍କ ସୁବଳ ଦଣ୍ଡୁ ମାଧବ ବିଧୁଭୂଷଣ ଲଡୁ କର and ମାଡୁ ପ୍ରଧାନ dealt farsa blows on Bhagirathi while he was lying on the ground. They dealt farsa blows surrounding the deceased. Subala was holding Kati, so and so, so and so. On seeing this, I ran away to my side. Now, my lord, I can understand him getting down from his cycle and seeing an indiscriminate assault, my lord. But how can he depose to have seen Ronco dealing a blow on the back? How can he depose seeing Ronco having assaulted thereafter, my lords, from his back? All these things he could not have seen. And he says he ran away to his Sahi, my lords, after seeing the assault. And how could he have gone to his Sahi? He has gone to his Sahi by the same, crossing this, probably the same river. He could not have gone anywhere else.
And that way or this way, you have to cross the river.
Either way, he has to cross the river. Then your lordship may see what he has again stated at page 144.
Hmm.
144, my lords may see the fourth line. When Bhagirathi was being assaulted by the accused, none of them had stated anything to me or Prafulla, much less they had tried to assault us. After the accused left the place assaulting Bhagirathi, we left that place. I cannot say where the accused were. On reaching my Sahi, I shouted by saying the names of the accused who assaulted Bhagirathi for the hearing of the people of my Sahi, which is at a distance of 300 yards from this spot. Throughout the distance covered by my Sahi, there are residential houses. There are 4 to 5 houses in between the distance. Prafulla Karo, who was with me, was the nephew of deceased Bhagirathi. Prafulla belongs to Puruna Sahi. This is the evidence of PW1.
Yes.
Now, in order to correlate that, they should not have used that. I will draw your lordship's attention to few lines from PW4.
Other two. Processing the river.
Paragraph 2 of his evidence in chief, my lords, we can. Page 149. About 5 to 6 years back, one day, when I returned to my village from Saranpur, and before crossing the river, I heard the bomb explosion sound from the other side of the river. Your lordship may just mark this sentence. And now your lordship may look at the spot map again. He is coming from Saranpur. That is from the south side, my lords. Towards, on the road leading from Saranpur towards Godipada. He says that before he crossed the river is that river Kusumi at the top. Before crossing the river, he hears the bomb explosion sound from the other side of the river. Where is the other side of the river, my lords? The other side of the river will be automatically towards the eastern end, my lords, beyond the river. That is the village of the deceased, my lords. So the bomb explosions are not at Nuya side, but they are at the other side of the river according to PW4. And at that time, 2 to 4 persons crossed me with conversation that Bhagirathi was murdered. On hearing this, immediately I proceeded to Saranpur, informed the matter to the police. Now, my lords, if we accept the evidence of PW4, and the fact that he was coming from Saranpur side, proceeding to his village, and which he was to proceed by crossing the river, he hears the explosions of bombs from the other side of the village. And then he says that people who crossed him, they were discussing. So he goes back, my lords, and reports at the police station.
Spot matter.
Yeah, return to Saranapura, not from Saranapura. It was returned to Saranapura.
Huh?
That is returned to.
Return to my village from Saranpur.
From Saranapura.
From Saranpur, she nije କହିଛି para 2 ରେ
Return to.
ମୋ ଗାଁକୁ ଶରଣକୂଳରୁ ଫେରୁଥିଲି, ତେଣୁ ଶରଣକୂଳରୁ ସେ ଫେରିବ କୋଉଠି? ଦକ୍ଷିଣ ଦିଗରୁ ତା ଗାଁକୁ ସେ ଫେରୁଛି। ମ୍ୟାପଟାକୁ ଦେଖ।
ଘରଟା ହଉଛି PW4 ଘରଟା ହଉଛି ସାମ କଣ ଗୁଣ୍ଡ ନା କଣ ଲେଖା ହେଇଛି?
ହଁ, ସାନ ଗରଡା ପୋଲିସ ଷ୍ଟେସନ ଶରଣକୂଳ।
ହଁ, ସାନ ଘରଟା ଠିକ ଅଛି। ସାନ ଘରଟା କୋଉଠି?
ସାନ ଗରଡାଟା ହଉଛି ପରା ସେ ଚାରିଟାକ ସାହି, ନୂଆ ସାହି, ପୁରୁଣା ସାହି, ଟୋଟା ସାହି, ଆଉ ଗୋଟେ କି ସାହି?
ଶରଣପୁରଟା ହଉଛି ଏପଟଟା।
ଆଜ୍ଞା, ଶରଣକୂଳଟା ହଉଛି ଏପଟେ, towards the south, ଗୋଡିପଡାଟା ହଉଛି towards the north।
Before crossing the river ମାନେ ଯୋଉ କୁସୁମୀ river।
So before he crossed the river, my lords, which is towards the west, he hears the sound of bombs from the other side of the river, and 2 to 4 persons cross him, conversing that Bhagirathi is murdered. So instead of crossing the river, he proceeds back to Saranpur.
ଏଇ ତଳେ ବି ଲେଖା ହେଇଛି ଭିଲେଜ ସାନ ଗରଡା ନୂଆ ସାହି।
ଆଜ୍ଞା,
ସ୍ପଟ ମ୍ୟାପ ର ତଳେ।
ଆଜ୍ଞା।
So, why you place this evidence of PW4?
I place the evidence of PW4 to correlate, my lords, the evidence of that other witness PW1, which I was placing that there is a shorter route, my lords, to the house of this deceased, and the incident has not happened in this place. This will be apparent again if your lordship will go to the evidence of the other witnesses. One of those witnesses has stated that there was no seizure of bloodstained earth from this spot.
Because if Mr. Konda, if PW4's evidence shows that by the time he came, that main part of the assault is over.
Yes, yes.
Because by that time he was hearing the bomb sound.
Yes,
which is obviously
that is the second part.
the second phase of the operation. So that phase was going on. At that point of time, he heard something from the villagers, and instead of coming to the village, he returned
going to his side, he goes back from the river.
Again to Saran.
So had this incident already happened by then, you would have seen that, my lord, the deceased lying there on the road. କାହିଁକିନା ସେ ପରା ସେଇ ଶରଣକୂଳରୁ ସେଇ ରାସ୍ତାରେ ଆସୁଛି। ମେନ୍ ରୋଡଟା ଆଜ୍ଞା ଶରଣକୂଳର ଯୋଉଠି ଇନସିଡେଣ୍ଟ ହେଇଛି ସେମାନେ କହୁଛନ୍ତି।
ଡେଡ୍ ବଡିଟା ତ ସେଇଠି ପଡିଛି ଦେଖଉଛି।
ଇଏ ଲୋକଟା ଆଜ୍ଞା ଯଦି ଶରଣକୂଳରୁ ଏ ବାଟେ ଗଲା ଧରିକି କୁସୁମୀ ନଦୀ ପାଖକୁ, ତାହେଲେ ସେ ତ ସେଇ ବାଟ ଦେଇକିରି ଯାଇଥିବ ନା। এটা স্পট ଦେଖଉଛି ଆଜ୍ଞା, କିନ୍ତୁ କୋଉଠି ଇଣ୍ଡିକେଟ କରୁନି ଯେ ବଡି କୋଉଠି ଆଜ୍ଞା ପଡିଥିଲା।
ସେ ଯୋଉ ଗୋଲ ବୁଲେଇଛି
ସେ ଖାଲି ଲେଖା ହେଇଛି ସ୍ପଟ।
ବିଟା ସେ ତଳେ କୋଉଠି ଗୋଟେ ଲେଖା ହେଇଥିବ, ସେ ଯୋଉ ବି ବୋଲି ସେଠି ତା ଭିତରେ ଗୋଟେ ବି ନା କଣ ଗୋଟେ ଲେଖା ହେଇଛି। ସେ ଯୋଉ ସ୍ପଟ ଏମିତି ଗୋଲ ବୁଲେଇ
ଆଜ୍ଞା,
ତା ଭିତରେ ଗୋଟେ କଣ ଲେଖା ହେଇଛି, ବି ନା କଣ ସମଥିଙ୍ଗ ଗୋଟେ ଲେଖା ହେଇଛି।
ତା ଭିତରେ ଆଖେ ଲେଖା ହେଇଛି।
ହଁ, ସେ ଗୋଟେ କୋଉଠି ଦେଖିଥିବ, ଏଇଟା କଣ ଦୁଇଟା କଣ ଏମିତି ଗୋଟେ ଦେଖାନ୍ତି ତ ସ୍ପଟ ମ୍ୟାପରେ। ବଟ୍ ବମ୍ସ ଗୁଡାକ ତା ପୂର୍ବରୁ ଲେଖା ହେଇଛି ସବୁ ବମ୍ସ ଗୁଡାକ।
ନରସିଂହ ପ୍ରଧାନଙ୍କ
ହଁ, ଶରଣକୁଳ ଆସିଲା ବେଳକୁ ଏ ବମ୍ ଗୁଡାକ ଆଗେ ପଡିଛି,
ତାପରେ ସ୍ପଟ, ତାପରେ ଆଜ୍ଞା କୁସୁମୀ।
ହଁ, ମେନ୍ ରୋଡ ହେଇକିନି ଗୋଡିପଡା ଆଡକୁ ଯାଇଛି ସେଟା।
ଆଜ୍ଞା,
ଆଉ ସେପଟ ସାଇଡ ରେ ହଉଛି ମାନେ ସେଟା ହବ ୱେଷ୍ଟର୍ଣ୍ଣ ସାଇଡ ରେ ହଉଛି କୁସୁମୀ ନଦୀ ଯାଇଛି।
कुसुमी नदी टा आज्ञा जाइए हाँ
हाँ उस वेस्टर्न
पश्चिम
साइड
साइड
से रास्तार वेस्टर्न
साइड।
साइड पूरी अब हाउस ऑफ डिसीज टा से देखौचंती
आज्ञा
सेपट साइड रे
नदी से
नदी सेपट
आज्ञा
ଏମାନଙ୍କର ଏଭିଡେନ୍ସ ହେଲା ଆମେ ଗୋଡିପଡା ଆଡୁ ଆସୁଥିଲୁ
ଆଜ୍ଞା।
ଯୋଉ ଭେଜିଟେବଲ୍ସ
ଆଜ୍ଞା।
ପରଚେଜ
एक के पाँच सौ
that is how you argue that if he was coming to his house from Godipada side,
आज्ञा
he would have gone to that his own house. Why he came to that
You
place where
could have crossed the cabin and proceeded towards the
but the dead body was found there. मतलब
डेड बॉडी टा आज्ञा हॉस्पिटल रे जाई कहउछथि
ନାଇଁ,
कोउठी
ନାଇଁ,
डेड पुलिस आसला
ଏମାନେ ଯୋଉ କହୁଛନ୍ତି ଘଟଣାଟା ହେଇଛି
ଆଜ୍ଞା
ଡେଡ୍ ବଡି ତ ସିଫ୍ଟ ହେଇଯାଇଥିଲା ମାନେ
ହଁ।
ବଟ୍
ଘଟଣାଟା ହେଇଛି ଏଇ ଜାଗାରେ
ଏଇ ଯୋଉ
ଏଇ ଯୋଉ ବମ୍ ଯୋଉଠି ପଡିଛି ଆଉ ବିଟୁ ସ୍ପଟ ଯୋଉଠି ଦେଖା ହେଇଛି ସେଇ ପାଖାପାଖି
ଅବଭିୟସଲି କୃଷ୍ଣ ପ୍ରଧାନର ଘର ସାମ୍ନା
ଆଜ୍ଞା କୃଷ୍ଣ ପ୍ରଧାନ ଯଦୁ ପ୍ରଧାନ
ହଁ,
ସେମାନଙ୍କ
ସେଇ
ଘର ପାଖରେ
ପାଖାପାଖି।
ଆଜ୍ଞା ସିଏ ଦି ଜଣ ଯାକ କେହି ଆଜ୍ଞା ସାକ୍ଷୀ ନାହିଁ।
ଆଉ ଗୋଟେ ହଉଛି କୀର୍ତ୍ତନ ପ୍ରଧାନ ଏଇ ତିନି ଜଣଙ୍କ ପାଖରେ
କୀର୍ତ୍ତନ ଘରୁ ଆଜ୍ଞା ଦିଟା ଲାଇଫ ବମ୍ବ ରିକଭରି ହେଇଛି
ହୁଁ,
ରାତିରେ
ହୁଁ,
ସିଏ ବି ଆକ୍ୟୁଜ ନୁହଁ।
ହୁଁ।
Now shall we proceed to PW5?
Yes, yes.
152.
I is that page 152 of the grounds.
You can show the relevant portion.
Yes, yes. Para 2.
Hmm.
On that day at 4 p.m., I with one Golaka Pradhan PW1 and Bhagirathi Kaur had been to Godipada Bazaar in 2 cycles to purchase articles. After finishing marketing, we returned to the village at about 6 p.m. I was pillion rider in the cycle of PW1. Bhagirathi was riding his cycle independently.
Hmm.
Now, my lords, may look at in the paragraph 3, your lords, you may see only one sentence. When we passed through his cabin, that is Subala's cabin, last line, found the accused Subala, Madhava, Dandu, Ranka, Duryodhana, alias Kalu, had assembled there. Again, he also doesn't say that they were armed or were having any threatening gestures. After we crossed the cabin, Bhagirathi Kaur, while passing the cabin, having followed us, I saw accused Rankanidhi dealt a farsa blow on the back of Bhagirathi. This witness, milords, is riding pillion. So he must be sitting, milords, with his face to the back of the person who is riding this.
Now, obviously, he would have no problem in watching it because he was sitting behind the PW.
Sitting behind, and he must be looking at one side only. Either
Not in that way. It is possible on his
Yes,
part.
it may be possible. I don't dispute that. Then he says that Bhagirath, I saw Rankar dealt a farsa blow on the back of Bhagirath. On such blow, he raised an alarm shouting, "Hey!" and ran ahead, leaving his cycle there. The other accused chased after him. After some distance, 2 to 3 accused persons obstructed him from his front side. For this, he could not proceed further. At that time, Rankar dealt another farsa blow on his left cheek, and so Bhagirathi fell down and dragged to a little distance. Due to this blow, he sustained a cut-incised wound on his cheek from his mouth to his ear. So then he says his left ear was also severe due to this cut-incised injury. Now there is no severance of ear. There is an injury on the mouth, milords, from mouth to the jaw.
We have asked Mr. Junior Panda to prepare a chart as he.
We have prepared it. We'll hide it.
FIR
Again.
এটা PW1 not stated amako the issue type. All right. Yes.
Then, my Lord may see, he has described who was holding what. And he says that Subala, Dondu, Kalu, Madhava, they surrounded Bhagirathi, assaulted him. Thereafter, many persons of their group assembled.
And just mention that 193.
This is a rough which we have prepared. If Lordship will kindly have a glance, Lordship will tell us what to modify.
193, right? ये type रो ठीक अछि जो खाली 193 ये होची 47 ना कोन से दारडा
हमें लिखि देइछु ना जगह रे appellant so and so
ठीक
of
है।
so and so with scissors.
It's FIR 161, 164,
IU.
position in court and contradiction.
Aye.
Okay.
Para 5 आज्ञा देखो
এটা মানে প্রথম जो congregation তারপরে
Page wise.
assault
ଆଜ୍ଞା
ତାପରେ assault ର ମାନେ part ରହୁଛି जो
ନାଇଁ congregation obstruction assault ତାପରେ bombing.
ତାପରେ assault ତାପରେ bomb ଏତିକି ତ ଚାରିଟା phase ନା
ଆଜ୍ଞା
alright ଠିକ ଅଛି ତ yes next
Para 5, my lord, may see what it says. I informed the incident in my Sahi, and so many persons of our Sahi came to this spot. But the accused persons threw bombs at them, and so they could not reach this spot. Now he introduces the appellants in the other criminal appeal. Accused Golli, Vidhubhusana, Abhimanyu, Harihara, Kishora threw bombs at them. Then at 9 p.m. the police came. This is important. I was sent for through the grammar of it. PW5. On my
this so far as the bomb throwing is concerned, this man specifically, or the PW5, specifically implicated the
appellants in 193.
No, 47.
47 of
And the same thing he has also stated in the FIR. He is the informant. But some other witnesses, like perhaps PW6 and 6, they have implicated some 193 accused also with this 47 who have thrown bomb. Yes. And similarly, so far as the assault part is concerned, PW5 has not stated that any of the 47 appellants assaulted to the deceased.
Vidhubhusana obstructed.
But this
was not
one and
one କୋହୁଛି କାଳୁ ନଥିବ ତାରେ କି obstruct କଲା ଜାଣି
ଏତଲାରେ କହୁଛି କିଏ କଲେ ମୁଁ ଜାଣିନି କିନ୍ତୁ ଏଠି ନେମ୍ କରୁ
नहीं 47 लोगों को तादेर तो पूरी नहीं PW5 कथा बोल
PW5
PW5 तो सब गुड़ा का 193 रो
193 रे कहिची तापरे आया देखो
now we are putting just making a query to you that PW5 either in the FIR or in his statement has he implicated any person from 47 who have either restrained the deceased or participated in the actual assault. That throwing bomb. I don't think we have verified. I think we have verified. They are all 193.
Page 98. Page 97 start 98.
Well, let us see. That was our impression that no one from 47 has been impeded either with restraining the deceased or assaulting. Who page number
page continue 97 running page.
FIR रे आया कहिला पेज 96 आगो देखंतु आगो पेज 96 देखंतु that is your lordship will look 7 lines from the bottom. जेउ मैंने जगिले सेमानक नाम कहि परिबि नाही किंबा चिन्हि परिबि नाही
नहीं विधुभूषण ना को ठीक है
आगो FIR रे देखो आगो कहिला FIR रे मु चिन्हि परिबि
हां ठीक है
तापरे हम कहूची ଏଠି ଆଜ୍ଞା କହିଲା ଧରିକିରି ଟ୍ରାଏଲ ରେ
नहीं नहीं 97
No, that is not our
Boma
query.
purpose
Our
ama
query is
jibon
that
ଚାଲିଯିବ
whether
ବୋଲି
he has implicated
ଯେଉଁମାନେ
any of
ବୋମା
the
ଫୋପାଡି-
appellants from 47
Assault.
either obstruction or assault.
Assault.
It is our query. Because we have also given the number accordingly. That who are the.
ଯେଉଁମାନେ ବୋମା ଫୋପାଡୁଥିଲେ
ନାଇଁ ନାଇଁ କହିବି। ସେଟା ଅଲଗା।
That's a different. ଆମେ confine କରୁଛୁ ବର୍ତ୍ତମାନ PW5 କୁ question ହଉଛି this much. I think all the 47 appellants have been
Named as the
named
asset.
as throwing of bombs.
Bombs only.
That,
Yes.
in FIR
ଆଜ୍ଞା
and also in the statement of PW5.
ଆଜ୍ଞା।
FIR ରେ ସେ କହୁଛି disease were obstructed by 2 to 3 persons of the same village which I cannot name nor identify.
ठीक है, sir, that's all right, but not named that 47 persons were there. ठीक है, वो चिन्ही परिबनी सर।
ନା।
ତେଣୁ ଏବଂ ଯୋଉମାନେ ବମ୍ ପକେଇଲେ ତାଙ୍କ
ସେଇଟା ହେଲେ 47
ହଁ 98 ର ପେଜ ରେ FIR ରେ କହୁଛି କିଶୋର, ବିଧୁଭୂଷଣ,
ଗୋଲି
ହରିହର
ଆଜ୍ଞା।
FIR ରେ then ଗୋଲି ପ୍ରଭୃତିଙ୍କୁ ମୁଁ ଚିହ୍ନିଛି,
ଆଜ୍ଞା।
ଅଭିମନ୍ୟୁ ମଧ୍ୟ।
ଆଜ୍ଞା।
They are all 47.
Yes.
A1, A2, A5.
Huh?
6 is
No,
not.
6 not there.
ହଁ
We have
ମୁଁ ନାଁଟା କୁହାଇ
taken note of it. Mr. Mishra is making dead sure that appellant number 6 has not been. We remember, Mr. Mishra, your argument and taken note of it.
Going very
Yes.
threadbare, but the whole point is that after the first argument, your lordship is very clear. But it has
Yes,
been
yes.
tested for thoroughly.
All right, yes.
Your
Next.
lordship is going very deep.
Yes, Mr. Pandit.
ଆଜ୍ଞା। Now paragraph 6 my lords please. Page 150
PW5.
ଆଜ୍ଞା। At 9 p.m., the police came to the village. I was sent for through the Gramarokhi. On my arrival, they asked me about the incident, which I narrated before it. Police reduced into writing my oral report, then read over the same to me, took my signature thereon. Then one sentence thereafter, I signed on the report after satisfied with the contents reduced into writing by him as per my report. EW4 was present when I gave statement to the police. He also signed on the FIR. PW4 ହେଲା ଉଦୟନା। ତାପରେ କହିଲା, police took me to the spot in that night where they seized some earth having bloodstain mark, a chappal and a wristwatch from the spot. The wrist,
So the scribe is one of the police officials.
yes, scribe is the IO himself, PW9.
Okay, it's all.
The wristwatch was HMT Kajal. They prepared a scissor lift, took my signature. Wristwatch belonged to deceased Bhagirathi. This is the wristwatch marked MO1. This is the chappal marked MO2. जो चप्पल टाको आगे कहला PW1 मोर चप्पल बोली, 5 कहूनी जे एटा PW2 र चप्पल, 1 र चप्पल। ते खाली कहूची दिस इज द चप्पल। तापरे आगे देखंतु Scissor को we let us forget about the scissors because the scissors are in no way material.
Important lines.
Important is paragraph 10. The police searched the house of the accused Subala and recovered a sickle, kati, arsa, 2 tangis, and a busa having bamboo handle, having a bloodstain mark in those weapons. Now, there were no bloodstains were detected from those weapons as per the chemical. Now, my lords, may kindly look at what he has stated in the cross-examination. Now, EW1 in his cross-examination, para 13 has stated that he was present when the description was given by PW5 about the incident to the police. Now, what this witness says in cross-examination is this, para 12. I was at a distance of 4 to 5 cubits ahead. Page 156. I was at a distance of 4 to 5 cubits ahead when the first blow fell on the back of Bhagirathi. At that time, I was sitting on the backside carrier of the cycle. After the first assault, I got down from the cycle and I proceeded slowly walking ahead up to 2 to 3 cubits. PW1 also got down from the cycle and proceeded ahead along with. Is this expected of a person? Either he runs or goes to the rescue of the other person.
No, the main point is that if this person is accepted, then by the time the assault on Ronco was there,
Assault by Ronco.
the man was riding the cycle and this man was, all that cycle was in that position.
Yes.
So nobody has got down. So that is your submission that how PW1 who was riding at that point of time, how he could see
Exactly.
the assault on Ronco. Because at that time, after that first assault, he
Got down.
So thereafter, the chance of the rider getting down would
And seeing the incident will arise. Then he says, Bhagirathi was assaulted at a distance of 10 to 12 cubits from us. This assault, I mean to the assault made on Bhagirathi by Madhava, Subala, Dandu and Tai. I have stated in my affair. I cannot identify or tell the names of 2 or 3 persons who obstructed Bhagirathi from his front side when he tried to escape after receipt of assault from Ronconidhi. Witness volunteers and says that in view of the situation and circumstances prevailing on that day, I stated so to the police. Had those 2 to 3 persons not obstructed Bhagirathi, he could have escaped and avoided further assault. I know the accused in the dock by their name from my childhood. This is important. So, who are the obstructors? If he knows all the accused in the dock by their name from childhood, how could he not name who were the obstructors? Then, paragraph 13 is important. 2 bags of grocery articles were hung on the cycle handle of PW1. Of them, 1 bag belonged to PW1, another of mine. After Bhagirathi was assaulted and fell down, I left the spot out of fear to my side and informed the incident to persons of my side, who immediately came to the spot, and I also accompanied them. The next sentence, my lords, we left the spot along with the cycle and the grocery articles. This, my lords, is an improvement, my lords, to explain away the non-finding of the cycle and the grocery article. He says, we left the spot along with the cycle and grocery articles back. I do not remember if I have stated to police and also in the FIR that I, expecting danger, myself and PW1 left the place, leaving the cycle at the spot.
But Mr. Panda, suppose let us say, in view of the whatever evidence this witness has given in paragraph number 12,
Miller.
that it would not have been probable for PW1 to mark the assault by Ronco on the backside of Bhagirathi.
Yes.
But all the same, let us exclude that portion from evidence of PW. Then what about PW5 and PW6 who have stated about that assault by Ronco?
Yes. There my submission is this.
Let us exclude that it is PW1. It may not be possible to that.
Exactly, Miller.
Yeah.
So far as PW5 and 6 are concerned, your lordship may just let me read this out and then I will explain.
Yeah. कोटा कोड देंगे
ये जो क्रॉस एग्जामिनेशन जो पैटर्न
पैराग्राफ 12 तो
नहीं पैराग्राफ 12 तो मैं पढ़ी चल
हां
पैराग्राफ 14 रे से कहिला fourth line, we left the spot along with the cycle and the grocery articles back. I don't remember if I have stated to police and also in the FIR that expecting danger to myself and PW1 left the place, leaving the cycle at the spot. suggestion taku diya haiti that before the arrival of the police they have put bombs there to create evidence jota se mana kar. The next line ta important. I cannot say who removed oblique shifted Bhagirathi from the place of occurrence. I also cannot say where he was shifted. My house is situated at a distance of a 3rd kilometer from the place of occurrence. Place of occurrence was inside of Nuasai. In between the place of occurrence and my house, of the houses of many persons situates, and of them, many persons belong to my family. I heard that Bhagirathi was moved to the hospital. I cannot say from whom I heard about it.
So that is how Mr. Dhod was also arguing that he is closely related to the deceased.
Exactly.
And then he would have at least accompanied the deceased while he was in a moribund condition to the hospital. But his statement that I cannot say who removed and remaining present there, it creates a doubt that we have noted down.
Then he says, ତାପରେ କହୁଛି ପାରା 60 ଦେଖନ୍ତୁ. If one would come from Saranpur side, he has to pass through my house. I had no prior acquaintance with the police officer of Saranpur. I cannot say if the Gramarakhi had accompanied police of Saranpur. Police took down my oral report into writing near a place situated from a distance of 15 to 20 cubits from the place of occurrence. And that place was within Nuasai. ତେଣୁ ପୁଲିସ ଆଜ୍ଞା ପ୍ରଥମେ ଆସିଛନ୍ତି ତାଙ୍କ ସାଇଡ୍. It is not a fact that, and he says he has no prior acquaintance with the police officer. The IO has stated that he searched who is this person.
IO evidence ଅଛି ଯେ ଆସିଲା ପରେ perhaps he met some other person.
Other person.
Then he recorded this statement.
PW4
can say grammar of you
No, Mr. Dhod was placing.
PW4 says I accompanied with PW9 to the spot and PW9 asked about Prosecution.
ନାଇଁ PW even IO କହୁଛି ମୁଁ ଆସିକି ପହଞ୍ଚିଲା ପରେ I think I met some other persons. Then I met this PW5 and as per the oral version cross-examination.
You were sent by the Gramarakhi.
Chief.
Gramarakhi को से डकेला कि ताको डकेला.
Well, let me see page 150, paragraph 3.
That we have marked that is PW4 तो
ନାଇଁ
IO ନିଜେ ମଧ୍ୟ କହୁଛି IO କହୁଛି ଯେ ଗାଁକୁ ଆସିଲା ପରେ he immediately did not meet this PW5, rather he met with some.
He asked about Prosecution. How could he know, my lord, Prosecution has seen the occurrence? When PW4 says I accompanied with PW9 to the spot and the specific question has been put whether you have stated anything to the police, he said no, we were silent. Wrong.
No, he is not aware because he left it from a without coming there.
So
he had no acquaintance that who had seen the occurrence, how the occurrence has taken place. So he gave the report on the basis of which that stationary entry was made, and he accompanied the IO to the village. That is the evidence, though.
But IO says I searched for Prosecution. Prosecution देखिए Prosecution घटना eyewitness say how could he know? Who was informed? And also PW5 is not saying that I volunteer myself. Police ଆସିଲାଣି ମୁଁ ଯାଇକି କହିଦେବି.
PW4 ଯିଏ ଯାଇକି ପୁଲିସକୁ ଡାକିଛି ସେ କହିଲା ମୁଁ ଅନ୍ୟ ଲୋକଙ୍କୁ ଶୁଣିଛି କାହା ନାଁ କହିନି. ଏମିତି ଘଟଣା କଥା ନାହିଁ, ଖାଲି
ଘଟଣା ବିଷୟ ତାର ଧାରଣା ନାହିଁ, ଖାଲି ବମ୍ ପକେଇଲା ଶୁଣିଲା.
ଆସିକିରି ଯୋଉ ପୁଲିସ ଏନକ୍ୱାର୍ଡ ପ୍ରଫୁଲ୍ଲକର ଯୋଉ ଇଏ କହିଲା ଷ୍ଟେଟମେଣ୍ଟରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ ଫାର୍ଷ୍ଟ ଲାଇନଟା, that creates itself doubt. So page 150 ରେ କହିଲା paragraph 5, ଉଦୟନାଥ କର କହୁଛି soon after the police reached in my village, searched inquired ପ୍ରଫୁଲ୍ଲକର. ତୁ ତ ନିଜେ ଜାଣିବୁ କିଏ ଦେଖିଛି କଣ କରିଛି. ଏବେ ଆଜ୍ଞା ଏଇ ଯୋଉ PW5 ର କେବଳ ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ ଇନ୍ କ୍ରସ୍ ଏକ୍ସାମିନେସନ that will be at page 160. This is to explain about PW6 members. Para page 160 last part evidence. I cannot say if PW4 had accompanied the police, but he was present near the police when I lodged oral report. All the above search and seizure took place in the night of 2891. IO visited our village every day continuously for about 15 days to investigate the case.
PW4 says when the statement of PW5 and 1 was recorded,
I was present.
Abhi was present.
Ah.
Abhi, I'm sorry, that's go.
Prafulla was present.
Then go that PW6.
6 was.
Yogi.
Yogendra. PW1 goes to Prafulla. Tell the truth.
Now with regard to PW6, the witness who has testified about 4 cases after police. At that page 161.
Correct. Para one.
उदयनाथ करो किए
তারপরে PW6
ना ना
PW4.
উদয়নাথ কর হচ্ছে PW4
हाँ
যে স্টেশন
जार बेसिस स्टेशन
হ্যাঁ
So far as this IO is concerned, what Mr. Dholo was arguing, apart from the statement of PW4 that he was regularly coming and investigating the matter, the IO himself has stated that after recording some statements of PW4, PW1, PW5, he was in search of who are the other persons.
Yes, that is
having
categorically.
knowledge about the occurrence or the eyewitnesses, but nobody could say
Exactly.
about anybody. That is how this man again came up after 4 days,
4 days.
gave statement that. So that he stated that that was a reason also to why he did not volunteer to give this statement. Yes, anything else, Mr. Panda?
Now PW6, your lords, you may see one. What he says is like this. First paragraph, what he says, that he saw the incident from the house of Abhijana of Nuas. Who is his brother?
Page कहते हैं PW6 ना?
Page 161.
हाँ.
I know the accused in the dock. Bhagirathi of my village has been murdered by the accused on 28/6/91 at 6 p.m. Abhi of Nuasai is my brother-in-law. On that day, I was present. In his house, standing on the outside veranda. Now, in the spot map, Abhi's house is not shown anywhere.
Same village. They are
Ah.
the Sanagoroda is the
I am saying,
adjacent. Only divide is Sahi Guda,
Aye.
but it belongs to same
same Sanagoroda, different size.
size of the.
ये साई का भीतर नुआ साई है उसे आर साई भीतर डिस्प्यूट ये कहूची I saw deceased Bhagirathi come from Godipada side riding a cycle. Goloka and Prafulla came in another cycle. They were coming followed by each other. That means Bhagirathi came following Goloka and Prafulla. ये अभी क्या है देखो नेक्स्ट पैराग्राफ नेक्स्ट पेज रे कौन को In the grocery shop at Nuasahi belonging to accused Subada, Subada was holding a katti, Madhava was holding a Bhalikam Dhusa, Rampa was holding a Farsa, Durjadhana was holding a Farsa, and here he introduces one of the appellants, that is number 2 in the other appeal.
47, not there in the fire or
or in the evidence of 1 and 5.
He was also present there.
Accused Bidhu Bhushan Patnaik was holding a farsa. They were standing in front of the shop of accused Subada. Goloka, Prafulla passed through the shop of Subada. When Bhagirathi reached near the shop of Subada, all the above 5 chased after him. So he ran away throwing his cycle.
So that is your submission that when the other 2 have not stated that they saw any of the persons while they passed through the Subad's cabin or
being armed,
this man has stated that.
And specific they have not seen, neither they were abused nor also threatened.
Right from the beginning ରୁ କହୁଛି ଯେତେବେଳେ ପାସିଂ କଲେ ମଧ୍ୟ ଏ 2 ଜଣ 1 and 5 ସେତେବେଳୁ ମଧ୍ୟ ଏମାନେ ତାଙ୍କ ଦୋକାନ ଆଗରେ ଏ ସବୁ ହାତ ହତିଆର ଧରି ଛିଡା ହେଇଥିଲେ.
यार further development ହଉଛି assault ରେ ବି he has included people from the other.
No, that has been proved through the, of course, the investigating officer that these are all subsequent developments. It's not there in the.
Cross-examination, your lords, you may see only 1 or 2 lines and closing. Paragraph 4. That is at page 163.
Paragraph 4, these questions have been put about to just create grounds for the delayed disclosure.
Yes.
That you are present there.
Yes.
This where investigation was going on.
Me.
And all these things, but you did not volunteer. That is how the line of cross-examination is.
Exactly.
Number of things you brought out.
The entire paragraph 4, he admits his presence, he admits the presence of the police, he admits that he has not gone to the spot when the police came, and he also admits that...
The last line of your paragraph number 4 in page number 163,
that the police is investigating the case for all these 5 days in the village.
That was pointed out by Mr. Dhar also. That then, if you are aware about the occurrence and you know that police has come, and then why you remained silent, did not come give the evidence. His statement was recorded on 2791. Is it 91 or
91?
91.
Then his statement has also been recorded under 164.
Exhibit C.
That has been marked as an exhibit on behalf of the defense.
no, this delayed disclosure, like in some cases they have stated that after the occurrence we went to a friend's house or to our relations house,
He
then,
has not stated anything.
no, it's not that. They give some type of explanation, but this witness has stated that I was very much present.
Or he was afraid of the accused
No,
persons, they are having antecedents.
No.
Nothing is there.
After the arrest, I came to know, I came and volunteered. So that is not the case here.
Paragraph 6 cross-examination.
Paragraph 6 to page 164,
Paragraph
two line 10.
6 ରେ କହିଲା accused Hajari Pradhan threw the cycle of Bhagirathi in the well during the incident. ଏଇଟା କେହି କହିନାହାନ୍ତି ଏ କଥା well ରୁ ବି ବାହାରିନି and Hajari is not an accused. I cannot say
Who else had seen
who else had seen accused Hajari throwing the cycle of Bhagirathi in a well, which is situated very close to the place of occurrence. I cannot say when that cycle was lifted from that well. I have stated to the magistrate about Hajari throwing the cycle in a well. I have not remembered if I have stated so to the police. Hari Pradhan is not my relation.
161.
I think the IO has stated that I came and
ଆଇଓ କହିଥିବା ମୁଁ ଖୋଜିଲି ପାଇଲି ନାହିଁ କିନ୍ତୁ PW7 କହୁଛି ଯେ କୋରୁ ବାହାରିଲା।
yes.
Now, the most important thing, my lords, is the evidence of the doctor. The entire description of the assault which these witnesses have given, my lords, and the use of the weapons which they are stated to have made. Now, the doctor's evidence totally, my lords, negates that.
How? Because of that, he has stated in the cross-examination that
Yes, please.
excludes some weapons.
Fine.
All these.
Though in the chief examination, he has
Yes.
given the statement that it is possible, and but at least 4 weapons in the cross-examination he has excluded, and no re-examination on that point. And State Council submit that the London Trial Court passed some stricture against this
Yes.
was conducted.
And he has explained as to why, how it cannot be caused.
My submission will be that in cross-examination, the doctor admits from the nature of the injuries why these were the
He has given
not
that
be
it's not a vague statement. He is
Yes.
stating that for this reason,
Exactly.
this injury is not possible
Exactly.
by this.
And that is corroborated again, my lords, by the seizures from the house of Subala and the chemical examination. ଏଇ ଜିନିଷ ଗୁଡାକ ଯୋଉ prosecution attribute କରିଛି ଯେ ସୁବଳ ଘରୁ ଏଗୁଡା ସବୁ ରିକଭରି ହେଲା in presence of eyewitnesses PW1 and 5 ସେଗୁଡାକ ସବୁ C report doesn't show any presence of blood that they were used in any way.
Except latte, but latte is
Now, these things, my lords, make the prosecution story suspect. And the most important aspect, my lords, is the evidence of the IO himself. The IO himself in cross-examination, my lords, has admitted several things which makes his investigation suspect. Now, he also doesn't say as to where from he got the knowledge also about the deceased having been shifted to hospital. My lords may kindly look at his evidence at page 174, my lords. We'll begin from 173, my lords, he begins. In the 4th line, your lordship will see he says like this. That he entered the fact in SD entry number 507, proceeds to the village to inquire into the matter, receives an oral report from Prafulla Kara, reduces it into writing, treats it as FIR. This, my lords, is contrary to what PW4 says about what happened when they reached. He said, but he admits that Udayanath Kaur PW4 was present at this point. Now, your lordship may look at the next page. I examined complainant at this spot, second line I am reading. Examined Udayanath Kaur, got information at this spot that deceased Bhagirathi was treated in PHC Saranpur. So I sent information for guarding the dead body at Saranpur hospital. Then look at what he has stated in paragraph 3. MO1 is the wristwatch seized by me at the spot. MO2 is the Hawaii chappal. I seized 2 bamboo lathis having bloodstains from the spot in front of the house of Kartika. Prepared seizure list. Seized 2 unexploded bombs near the spot in front of the house of Kirtan in presence of witnesses. Prepared seizure list exhibit 3. And he gives the description of the MOs. Paragraph 4 dekhantu. I examined a witness at the spot on 28/29/91 at 1:30 AM, searched the house of accused Subala, recovered a kotari having bloodstains, a da, parsa with 2 kuradis with wooden handle, a bhusa having bamboo handle, and another sickle, seized them in presence of witnesses, write exhibit 7. And he identifies what he has seized, gives them the MO numbers. But in the C report, there is no bloodstain available anywhere. Paragraph 7, your lordship may see of the High.
No, just a minute, Mr. One line is just take note of it and you have to clarify. You made a submission the other day that this medical evidence is a opinion evidence, and when the eyewitnesses evidence is truthful, then mere discrepancy in the medical evidence is not a ground to discard the oral version. That was your submission the other day. But that if the oral evidence is of such a standard, then that is possible what you are telling, that even if there is some kind of discrepancies with reference to the medical evidence, then it's all right. But apart from the fact that the medical evidence excludes some weapon, if you see the evidence of these eyewitnesses, then so far as the assault is concerned, on a plain reading, you will find that the FIR includes 193 appellants in the actual assault. Is oral evidence also 193 people. PW1, on the other hand, includes some persons of 47 as well as 193. That is the thing. PW6 stands in a totally different footing because he in view of the delayed disclosure. So how you say that the evidence of PW1 and PW5 are so consistent that even if it is discrepant with the medical evidence, we will just ignore those discrepancies and rely the evidence of PW1 and 5 that they are absolutely truthful witness. If you just see that who are the assailants on the deceased actual assault, you will find that in page number 139, PW1, he has stated that 5 persons from 193. You come to that paragraph number 3, just see it, page 139. accused Ronko, Subal, Dondu, Madhav, they are all 193 people, appellants, right? And then whatever he has stated, this Vidhu Bhushan, Ladu, and Madhu, they are all 47 appellants. So total number of persons who have assaulted Bhagirathi by Farsa, according to this PW1, becomes 7, right? So according to this man, 4 from 193, 3 from 47 assaulted, actual assaults. And then if you go to the PW5's evidence, you will find that he has totally excluded 47 people from the actual assault. So the question of consistency, because you raised that point, we are asking you. So if the version of PW1 and 5 would have been consistent, it could have taken their evidence to a higher level. Okay. And in that way, even if some discrepancies are there with reference to medical evidence, we could have ignored that medical evidence and would have placed implicit reliance on the evidence of 1 and 5. But in view of this type of evidence, how can you make a submission that they are absolutely truthful witness so that any discrepancies with reference to the medical evidence be not given any importance? That you are to submit after Mr. Panda finishes his job. Yes, Panda.
Lords, you may look at para 7 of the act. It's at page 176.
Yeah.
On 2/7/91, I examined some other witnesses. On 9/7/91, I seized a black-colored Atlas cycle bearing number such and such, having purchased vegetables like potatoes, onions, etc. in a cotton bag, and those were rotten. Under Seizure List Exhibit 6, the cycle and the vegetables belong to the deceased Bhagirathi Kara. Deceased was coming from the market with those vegetables in his cycle. I gave the cycle in Jima of Fakira Kara, father of the deceased, under Jimanama such and such.
Is PW that
7.
Right.
Kotu seizure hela ye कहलेनी.
No, seizure point we have seen that discrepancies ଅଛି କାରଣ ये seizure ରେ ଲେଖା ହେଇଛି ସେ ବୋଧେ ଜଣ ଏଠୁ ବାହାରଲା କୂଅ ଭିତରୁ ବାହାରଲା
ଆଜ୍ଞା
ଆଉ PW7 କହୁଛି ମତେ ଆଣି IO ଦେଲା IO କହୁଛି ମତେ ଆଣି PW7 ଦେଲା but seizure list ରେ ଲେଖା ହେଇଛି କୂଅ ଭିତରୁ ବାହାରଲା. So that is how
ମୋର ଏ ଖାଲି କହିବା କଥା ଏଠି ଆଇଓର ଷ୍ଟେଟମେଣ୍ଟ ହେଲା ସିଜ୍ କଲା ଗୋଟେ ସାଇକେଲ having purchased vegetables in a cotton bag which were rotten. ଆଇଓ ସିଜ୍ କଲା ଯଦି ଏଇଟାକୁ ତାହେଲେ ଏଇ ଯୋଉ PW1 ଗୋଲକ ପେଜ 143 ରେ କହିଲା in cross examination para 12 ସେ କହୁଛି middle ରେ on the first blow Bhagirathi jumped from the cycle and started running. Cycle fell down there. Articles purchased by him lay scattered there. Bhagirathi ଦୌଡ଼ି ପଳେଇଲା ସାଇକେଲ ଗଳି ପଡିଲା ଜିନିଷ ଗୁଡାକ ବ୍ୟାଗ ରୁ ବାହାରିକି ତଳେ ଗଡୁଥିଲା ତାପରେ ଏହା କଣ ଭାଗୀରଥୀର ଭୂତ ଆସିକି ତାକୁ ଫେର ବ୍ୟାଗ ରେ ପୁରେଇଲା.
Somebody what they say that somebody perhaps has removed that cycle and that vegetables from the spot. That is how it was subsequently seen. That who is that person? Of course, this one man has stated that that was one accused or somebody who is not an accused in this case. He just read it out that.
ତାପରେ ଫେର କୂଅରେ ପଡିଲା ଯେ କୂଅ କହିଲା ଆଇଓ ସେଇଦିନ ଭେରିଫାଇ କରିବ କୂଅରେ ଆଇଓ ସେଦିନ ସ୍ପଟରେ ଦେଖିଲେନି କିନ୍ତୁ 9/7 ଦିନ କୂଅରୁ ବାହାର କଲେ ସିଜର ଲିଷ୍ଟରେ ୱିଥ୍ ଏ ବ୍ୟାଗ
Page 180 देखो proceedings
No, no,
180
IO ସେ
It's
ସିରିୟଲ ଲିଷ୍ଟରେ କୁହାଯାଇଛି ଯେ ପୁଅ ଭିତରୁ
ଆଜ୍ଞା
ହଁ
No, no.
ଏମିତି କଣ
180
Nine,
after
code of
recording
page
the FIR, it
180.
came to light the involvement of 2 cycles.
पेज 180 में लॉर्ड्स में सी व्हाट
Paragraph 15 man.
पैरा 15
ता ऊपर हटा फर्स्ट पढ़ो after recording the FIR, it came to light the
पेज 180 में लॉर्ड्स में
18 आरंभ पढ़ी
After recording the FIR, it came to light the involvement of 2 cycles and their importance and the truth of the case.
Hmm.
And in my spot visit, I had not seen either of the cycles at the spot or near about. There was a well by the side of the cabin of Subala Pradhan accused. I marked that well carefully, but did not find the lying of any cycle inside it. ତାପରେ କହୁଛି I had done investigation throughout the night of 28/9/91. I examined Bhagavata son of Kaivalya at about 2:30 a.m. of 29/6/91. I seized the cycle on production by Fakira Karo PW7. I seized it on 9/7/91 at 0:30 p.m. on production by PW7 at village Sanagoroda. I have not mentioned the particular place of seizure. The circumstance of seizure shown in column 5 of Exhibit 6 has been written on the statement of PW7. I have no personal knowledge about it. I have not inquired from Fakira or anybody else as to when they detected the cycle, the place of such detection, date of detection, by whom it was detected, how it came to the possession of PW7. Cycle was given to Fakira as he was the father of deceased. I have not inquired about the cycle of Goloko as that was not relevant for the purpose of this case. In fact, probably that was more relevant because witness having said that he threw the cycle has stated in his deposition that we went away with the cycle and the bags.
In fact, there is no charge also under section 201 of the Indian
No,
Code.
there is no charge.
Yes, anything further?
So in these circumstances, my lord, the other aspect your lordship will be that the evidence on record shows, my lord, that inquest witnesses were present when the FIR was lodged. That is, this PW7 was present, Udayanath Karo PW4 was present, and another son of Fakira, that is Brajabandhu, was present when the FIR was lodged. That is the evidence of the eyewitnesses themselves and PW4. But in the inquest, my lords, the names of the assailants are not mentioned.
That is, Mr. We have noted down that.
Even in the dead body challan, it has not been
That
mentioned.
is noted down.
That has to be taken into consideration along with the fact that the FIR has reached the court also with delay. So therefore, my lords, that this FIR was subsequently manipulated, that possibility cannot be ruled out. The other aspect that your lordship has to take into consideration is that in the accused statement, my lords, as I had pointed out on the last occasion, and the questions that were put, the questions that have been put, none of the questions are incriminating in any manner.
Now we have noted down.
Yes. And the other aspect is that when so many people were there, my lords, the charge is 1 under 302 read with 34 of the IP. Specific charge under 302 is against Ronco merely on the basis that these witnesses have stated that he dealt the first blow on the back. And the second blow of Ronco, severed 1 year, which is not corroborated medically. And in view of the doctor's evidence, my lords, that there is no injury which is suggestive of assault by a farsa, my lords. Can it be said that the prosecution has been successful in establishing the case against the accused persons? And can it be said that the accused were not prejudiced by such faulty examination of theirs under 330? In fact, I believe I pointed out to your lordship one of the questions where it is stated that the informant is PW2.
Even no question has been put pertaining to PW6 to accused oncologist.
Specific question kichi nahi to any of the accused that you were responsible for the injuries, that the injuries were caused because of the assault made by you, and that you are the persons who are responsible for having come with a pre-concerted plan to commit murder.
Charge was there, that is 302/34.
Yeah, charge is there.
This Ronco was separately charged under 302
Two also.
and all others with 302/34, apart from other offenses.
Aye. There is a judgment of the apex court, my lords, with regard to the 313 statements. That is volume 2020 10 SCC 108, my lords. Maheshwar Tigga versus State of Jharkhand. Paragraph 9, their lordship say that circumstances not put to an accused under section 313 cannot be used against him, must be excluded from consideration. In a criminal trial, importance of questions put to an accused are basic to principles of natural justice, as it provides him the opportunity not only to furnish his defense, but also to explain incriminating circumstances against him. Probable defense raised by an accused is sufficient to rebut accusation without requirement of proof beyond reasonable doubt. This court time and again has emphasized the importance of putting all relevant questions to an accused under section 313 of the CRPC. And here, if your lordship will look at the questions, my lords, how can these questions be said to be in compliance with the requirements of section 330?
କାଳୁର ଦେଖାଉଥିବ ଯୋଉଥିରେ କି ଅଛି କାଳୁର ହଉଛି କାଳୁ 108.
Whereas this Duryodhana for whom I am appearing, 108 is the relevant question. Same questions have been put to everybody. In fact, I don't deny, my lords, that the court has made corrections in respect of some accused. But here, my lords may see, especially the question number 7. That is at page 109. The PW2 lodged an oral report to the police on their arrival at the village on the same day night, and the FIR is Exhibit 9. He has made corrections for so far as other accused, some of the accused.
ଏଠାରେ ଅଛି question 3 ର 1
ତାପରେ ଦେଖନ୍ତୁ ସେଇ 109 Question 4. Near the shop of Subala Pradhan, it was found that you, along with other accused, had gathered there. And when PWs 1 and 5 and the deceased Bhagirathi passed through you, Ronco suddenly dealt a fatsa blow on the back of Bhagirathi Kaur, as a result of which he started running by throwing his cycle there. What do you say? How does it inculpate me, my lords, in any manner? The fatsa blow being dealt by Ronco Naik, how is it inculpatory so far as this appellant is concerned? That this question was put to him. And then you, along with others, chased after Bhagirathi, surrounded him at a little distance, so he could not proceed further. Thereafter, Ronco having dealt a farsa blow on his person, he fell down. What do you say? It is କେମିତି ମୋଏଲ Then after his falling down, you along with other accused persons assaulted him by means of different kinds of sharp cutting weapons. Yeah, କୋଉ ସାକ୍ଷୀଟା କହିଛି କଣ କହିଛି ଯଦି ସେଇଟାକୁ ଆପଣ ପୁଟ୍ ନ କରିବେ ଧରିକିରି ତାହେଲେ ଏଣ୍ଟ୍ରି କାର୍ଯ୍ୟର ମାନେ କଣ? It's an empty formality. But he relies upon that evidence which has not been put to me, that X and Y have said this to you, that you are the author of such and such injuries, and I am convicted.
Prohibition.
W1, 2, 5, 1, 5 and 6 to 5. ଗୋଟିଏ sentence it transpires from the evidence of 1, 5 and 6. First question ହେଲା that on 2891 PW1 and 5 along with this is Bhagirathi had been to Godipada and they returned to the village in the evening. What do you say? They had been to Godipada in two separate cycles while they were returning to the village. 1 and 5 were coming in one cycle. Deceased was following them. What do you say? Near the shop of Subala, it was found that you along with so and so. That I came with it. Tapre, I would take in some medical is it. I got it. I use evidence Millers.
173 to stop.
Page 187 is important.
Okay.
Paragraph 17. That should be at page 182.
Order of Bhagirathi. Paragraph 7. 17.
For that para 17, page 182, the IO says, I have noted the substance of the entry made in the station diary number 507 dated 2891. This is exhibit 20 meters. Marked on the prayer of the prosecution and not being objected by us. The station diary disclosed about murder of Bhagirathi Kaur. Basing on that information, I proceeded to the spot. Station diary did not disclose the name of any of the assailants of Bhagirathi. There is some distance between village Bodogoroda and Sanogoroda. One road leads from Bodogoroda to Sanogoroda. In between the distance, no other village intervenes. Udayanath Kaur did not tell me from whom he received information that Bhagirathi was murdered. Now, if he got information about murder, Millers, that is a cognizable offense, Millers.
That noted down.
So instead of recording that as an FIR, the present FIR is hit by section 161 therefore. And my learned friend with reference to the police manual plays something before your lordship, Millers. My submission is, Millers.
That is, vague statement should not be
Yes.
recorded.
But if here specifically the IO admits that it disclosed about the murder, so it cannot be said to be a vague statement. Maybe the names of the assailants were not disclosed, but it disclosed that a cognizable offense had occurred. At least assault jo lekha hai, that itself discloses a cognizable offense. So in these circumstances, my lords, my submission will be that
In the-
Arjun
in the-
Narik and Mehraj Singh come into play.
Station diary entry, there is no mention that about the murder of this.
Na, station diary lekha hai assault was.
Sorry.
Assault. At this hour, Udayanath, son of so and so, came and reported that he was returning to his village Sanogoroda. Near village Bodogoroda, he got information that some persons had assaulted Bhagirathi in the village today evening and there was problem in the village. এটা মার্ক ହେଇଛି as exhibit by order dated 23/6/97 of the trial.
Examination of superior also is the important.
The grammar of Milord, he has not been examined.
Who was the first person to?
He has gone and called the informant to the spot.
And his house is nearer to the spot.
And if they went and the Gramaraki had gone and called this informant to the IO Millards, the Gramaraki should have been examined. The IO himself says that he saw the Gramaraki on the next day at the time of inquest. This again is doubtful.
And his name finds place on this case diary dated 29/6/91. IO paragraph 19 has categorically stated, I cannot say when the Sukuru Naik was met by me, but for the first time his name finds place in my CD recorded at 7:30 a.m. on 29/6/91. Sukuru Naik belongs to village Sanagroda. His residential house situates very close to the arrest spot. Very relevant witness, Gramaraki, and his name was very much there. And he is the person who was sent by PW9 to call PW5, the informant. They may not examine each and every witness, but they should examine the witnesses whose examination would have unfolded the narratives in the language used by the apex court.
Yes. So that's all, Mr. Panda. Just give your respective notes and citations and that chart which has been prepared and
Day after tomorrow.
okay. Anything in reply you want to say?
Yes, but anything when I so many things I have to reply.
No,
Give your written note about
give your written.
Yes, just I read some, but
We are closing the case today and just also indicate in that note about what we put to you, that how the oral evidence is reconciling with the medical evidence, because the doctor has excluded some weapons and the person of the eyewitnesses appears to be that there is little variation so far as the participants in the actual assault is concerned.
Here the case, my lord, Learned Senior has created a dent in the prosecution story. Now try to create a cloud in the prosecution story. Now create a sense of disbelief that there is no such occurrence. So in toto, I have to even though they are the statement of 1 and 5, and the appeal is a file in 2 sets. One is the assailant side, another is that on 34. The very clear cut mind that what will the brought in the notice of this honorable mind of the court that there should be segregated in 2 sets. Even though in 193 assailant parts are there are some improvisation or some embellishments are there in out of that statements, but the assailants are very clear. Who are the assailant in both the 1 and 5? The very instance when FIR lost at the very instance way by information within 1 hour police arrived at the spot and recorded. So criminal action set in motion very initial stage. It cannot be said there was a 2 days, 3 days, 2 hour, 4 hour delay. So then there will be doubt in the initiation of the criminal motion. The as submitted that the FIR is a concocted FIR or subsequently has been prepared.
No,
So for the
how do you reconcile PW6? It is stands in a different footing. How do you reconcile the evidence of these 2 witnesses? 1 and 5.
1 and 5. That
Let us confine about the assault part.
yes, on assault part.
This Ronco assaulted from behind. Then this main assault आसी तो देखिला ना evidence FIR और PW5 रो version होची assailants, assailants of that 193, and PW1 has, apart from them, he has included 4 persons from the 44 or 3 persons, I think, he has included. So 2 of the persons, because let us say
They
that
added.
Ronco assault is not possible to be seen by this PW one who was riding, but thereafter he got down. Both of them got down and they saw the occurrence. And that statement of these 2 witnesses vary so far as the participants of the actual assault is concerned. If we say that because the other person is totally, this 5 is totally excluding, it's not stated that any others apart from this 193 persons, any other persons were there or participated in this. His evidence is very specific that the appellants of this 193 participated. Now, your other witness was present along with him at that very place. He is stating that no, apart from them, 3 other persons were present, which has, of course, been proved through the IO, and that he has not stated in pleading for them for the first time. So, on the basis of this, that in a case under section 302, one of your witness is PW1, who is trying to impede some persons for the first time in the assault in a murder case. Can you say that he is a truthful witness, or implicit reliance we can place on his evidence? In a 302 case, a witness of yours is impeding 3 to 4 persons from 47 appeal, whom he has neither named in the 161 or 164. It has been proved through the IO's evidence. So, under what category you place it? Because that 3 type of witnesses, what you state, absolutely reliable, then absolutely unreliable, and partly reliable and partly unreliable. So, if you place this witness in the category of partly reliable and partly unreliable, so far as PW1 is concerned, then independent corroboration is necessary in view of that very decision. Then, if we see the corroboration, rather the medical evidence negatives that some of the weapons, because he has stated that these 8 persons assaulted by means of farsa, and the doctor says that by farsa these injuries are not possible. He is giving a reason, and you have not clarified by way of re-examination. So then, how you say that we can place on implicit reliance on these 2 witnesses and ignore the doctor's statement totally, whatever he has stated or what the defense has elicited from him in the cross-examination.
Thank you. If there is injury of 16, as you lordship, the doctor's statement at page 16, the 16 injury he has described. That is not disputed that there is no injury. The sum of the injuries on head. In the doctor has in the chief it has stated, injuries on the head are of the vital part of the body. The injury are sufficient ordinary course to cause the death of a person. So there are 2 injury on the part of it, that one in the left ear, another is on the right ear. So if at all the PW1 and subsequent assault on PW 2 attack was made, then that corroboration is made into medical evidence. There are twice Ronco was assault in ear. Then injury on head, page 69, there are 2 injury on ear. That assault of 2 part, as my learning said that the Bhagirathi was riding the cycle, there was no occasion to see who was assault by Ronco.
First assault, this is about the first assault.
My lordship, I just go back the what is the occurrence took place in 1991. The rural logistic persons, if they would have any inimical minded, they would have implicated the knowing each other. knowingly
There
nicked them.
was-
They would have, no, they would have implicated right from the inception to the person, they are the assault part. There is a very clear, lucid manner they have implicated who have assaulted and who have taken part in a other criminal act.
But in the trial stage, you are
Sometimes it is
in
the,
the
it is
trial
happening.
stage, you are trying to entangle more persons in the actual assault. That is the conduct of
That
the-
improvisation may not be taken away there.
No,
Percy cannot take away the entire credibility of that.
want us to rely on the evidence of
No, that what
such a
that-
person
again.
who is taking the names of other persons, including him themselves, in the actual assault of the deceased. And your IO has not recorded the statement. That is not there, as we have seen also that. And about even the charge under section, you see the minor charge, it may be 341. Your 341 charge, if the FIR statement is believed, then the 341 charge is against the appellants of 193. And same money restraint kale na deceased ko. Now you see that what the charge has been framed in the during the trial. The charge is framed against all that they have restraint. Now come to the conviction also. Conviction is against 3 persons of 47. 341 charge or conviction, you see, come to that operative part of the judgment.
Last part.
Last part. Kahaku
In separate, that are
हाँ,
47. Separate.
47 ର 3 ଜଣକୁ 341 ର
Okay.
ଆପଣ ଇଏ କଲେ ତାପରେ ଗୋଟେ vague line ଲେଖି ଦେଇଛନ୍ତି, but specific is that these 3 persons are you come to page 86 and see that I hold all the accused persons guilty under section 302/34 and hold the accused Madhu Pradhan is A7 in 47, Lodukar A6 in 47, and Vidubhushan Pradhan A2 in 47 under section 341/34. So your case in the FIR,
FIR madhyam Vidubhushan Harihar, others names are there.
charge ଟା କଣ ଦେଖୁଛନ୍ତି ତ 341 କଣ ପାଇଁ frame ହେଲା? You come to the
Illegal.
charge 341 ତାକୁ restrain କଲେ ବୋଲି frame ହେଇଛି charge.
Yes.
Be clarified on that. You come to the charge, page is 100. The first charge is 341/34. File is a charge under 3 heads. You see that on so and so at 6 p.m. under Saranpur wrongfully restrained the deceased Bhagirathi Kara in furtherance of the common intention. Got it? Page 100. है ना? तो charge टा 341 रो frame ହେଲା एइथि ପାଇଁ जे तमे भागीरथी कर को wrongfully restrain कलो. सेटा आपनकर FIR केस ହେଲା एति के लोक restrain कले. Charge frame ହେଲା समस्त restrain कले. Finding आसिला 47 वाला ताको restrain कले 34. Just get see it.
I know. With your lordship's permission, 2-3 ଜଣ ଅଜଣା ଲୋକ
No, that is there. That
yes
is there.
ଅଜଣା ଲୋକ ଜଗିଦେଲେ so wrong 341 is applicable to those 2-3 ଜଣ ଅଜଣା ଲୋକ and that has not all they have not got to picture attached to it itself ଜୀବନ ବିକଳ
341 no charge, of course, it's a minor offense, but see that what is the अपन देखिले FIR टा अछि ना अजଣା लोक evidence of PW5 informant again PW6 1 known persons and who are they now PW6 added some more names এবং finding আসিলা কোন ultimately যে it is only 3 persons from that 47 जो मानकर ना थिला कि शेष स्टेज रे जो बम पकेवा स्टेज कारण Mr. Mishra's client has not been convicted under that bomb throwing part. Have you seen it?
No, sir.
you see that he has not been convicted under that Explosive Substance Act. Who have been convicted, that is very clear from the judgment.
Goli Vidushan Abhi Harihara. And
Goli is a appellant number 1, Vidubhushan is appellant 2, that Abhi is appellant 5, Harihar is appellant 3, and Kishore is appellant number 4. These are all 47 people who have been convicted under 9B. It's not A7. A7 conviction है. A7 को कौन पाई conviction होला? Just हमें जो अभी देखे लो आपन को 341 रे conviction है जी, apart from 302 of course. तो 341 रे restraint कला deceased रो नाही नाही FIR. So in a case of this nature, if vague statements are coming, then the duty of the court, that the principle is that duty of the court is to see that against which accused the evidence is consistent. And the court has to rely on
this
that the evidence which is consistent. So it is not that we have to reject it entirely. That evidence is, suppose 5 जन accused, 5 जन witness गोटे unlawful assembly case रो witness अछन, right? एवं सेमाने तादेरे 3 जन करो 4 जन करो ना consistent आसुची, हैला? अन्य मानकर ना किए जणे कहिछि किए कहिछि, तेणु प्रिंसिपल टा होछि जोटी एई टाइप रो आसीबो, तेणु the court has to see that which name is consistent in all the evidence. Not that एई जनकर ना तो जणे कहिछि, at least you cannot. That is the principle. That while appreciating the case of that nature, the court has to be very careful that in that way. So आपनकर जदि evidence of PW1 को देखिबे, जोटा कि for the first time in court, you cannot say no to it because your IO says that they have not been implicated. So प्रथम थर फाइन कोर्ट रे आपनकर PW1 47 रो किछि appellant को include करूची actual assault रे, which is not there in the FIR, which is not there in the version of your other eyewitness with whom he is standing and watching the occurrence. तेणु एठी how far those 47 persons can be with the aid of 34 will be found guilty under 302 by 34. That was also asked apart from the fact that there is contradictions with reference to the medical evidence is there. Just give that note also, in not in exhaustive manner. Don't mention this prosecution case, etc. Just pinpoint जोड़ा का हमें कहिलु एवं आपनकर जो citations मध्ये rely करिवे आदरे जो particular paragraph ए point रे ए paragraph ता आपण rely करथुन ताकू ये करिके नहीं, and try to give it by day after tomorrow because we'll again assemble day after tomorrow. Right. We then why we reserve it?
We will not reserve it. We will keep it for day after tomorrow and we will reserve it that day.
On that day we'll receive the, so we are keeping it on the day after.
on that date only, I'll try to prepare up to that only by way of judgment I can demolish.
No,
the
जो just माने आपनकर written note of submission टा माने गोटे आउ गोटे माने 50 पेज रो 40 पेज रो करिवा कि
नहीं नहीं written not only.
prosecution case या PW1 या कोची 2 कोची आपण pinpointedly सेमाने जो जो argument कले तारी पर दियंतु सेमाने मध्य से ही देबे. It's not necessary to give a lengthy written note and also citation मध्य to the point आनो. आ गोटे point रे 15 टा decision दबा भी किसी आवश्यकता नहीं. गोटे point रे just 1 or 2 decision would sufficient and relevant paragraph. So this is it is to be kept there.
Your Lordship wanted to know whether that my accused, that is Ladu Kishore,
There is many material to show that is a government.
ଆଜି ଯୋଉ ଆପଣ କହୁଥିଲେ ଯେ କଣ ସ୍କୁଲ ଟିଚର
School teacher, he had filed OA. This one of the order. I have got the copy of the OA also.
No, no, Mr. Please, if you want to, you can file an affidavit. You are not filing anything. We have indicated to you also.
That was a comment, sir.
How just whatever material you can, and give a copy to the state council also. Yeah. With us,
And
The government they filed an OA also for retirement
for
benefit.
period of custody is concerned, most of them have spent more than 5 years, 10 years in custody.
14 years.
No, no. So far as life conviction is, there is no,
Yes, sir.
but it would be relevant for other things like you बाकी जो ये हमारा जो explosive substance act those are. Mr. Naik, anything you want to?
I have, as per your requirement direction, my lord, we have prepared a chart, my lord, against each of the accused
So
persons.
chart
application.
approach is let the two youngsters sit.
We have
together.
prepared it together.
see-
One thing I want to point out, my lord, from the beginning, my lord, there is no motive to commit this crime. Because your lordship may kindly see one page only, one line only from the affair. Lordship will find it. The Pradhan, my
No,
lord,
who's Haki?
page 95,
90?
94, my lord. 94 ରୁ ଷ୍ଟାର୍ଟ ହଉଛି।
Just a minute.
ଆଗରୁ ଥିଲା, ଆଜକୁ କିଛି ମାସ ତଳେ ଆମ ଗ୍ରାମର ସମସ୍ୟା ଠାକୁର ସମ୍ପତ୍ତି ନେଇ ଗଣ୍ଡଗୋଳ ଉପୁଜି ଗ୍ରାମର ଦଳାଦଳି ହୋଇଥିଲା। ମୁଁ ଭାଗୀରଥୀଙ୍କର ଉଗ୍ରରେ ଗୋଟିଏ ଦଳର ଅଛୁ, ମାଧବ ପ୍ରଧାନ ଉଗ୍ରରେ ବିପକ୍ଷ ଦଳ ଥିଲେ। ଗ୍ରାମର ସମସ୍ୟା ଅନ୍ୟାନ୍ୟ ବିଷୟ ନେଇ ଉଭୟ କୂଳ ବସି ଭଦ୍ରଲୋକଙ୍କ ଜରିଆରେ ଆପୋଷ ଭାବରେ ମିଳାମିଶା
वही जो रफानामा ହେଇଯାଇଥିଲା
ଆଜ୍ଞା, ରଫାନାମା ହେଇଛି, ସେଠି ଖାଲି ନୁହେଁ, ଥାନା ବାବୁଙ୍କ ପାଖରେ ରଫାନାମା ଦାଖଲ କରିଥିଲୁ ଓ ଉଭୟ ପକ୍ଷ ବଣ୍ଡ ଲେଖି ଦେଇଥିଲୁ ଭବିଷ୍ୟତରେ କୌଣସି ପ୍ରକାର ଗଣ୍ଡଗୋଳ କରିବୁ ନାହିଁ। ଦେୟାର ଆଫ୍ଟର ଇମ୍ପୋର୍ଟାଣ୍ଟ ରଫା ହେଲା ଦିନଠାରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ କୌଣସି ଗଣ୍ଡଗୋଳ ହୋଇନାହିଁ କିମ୍ବା ତା ମନାନ୍ତର ନଥିଲା। So if by
No,
that,
that's all right, but again,
That
Mr.
is there.
Naik, that suppose
There is no
this
motive.
motive may not be relevant in a
Always,
case where
always.
direct evidence is available.
But
So in a case of circumstantial evidence that may have that pertinent significance, but yes, if we disbelieve the witnesses matter,
Yes, sir.
but merely because the prosecution has not proved any motive, in a direct evidence case, can the witnesses be discarded on that ground?
in case of absence of motives, my lord, the court should
No,
guard.
obviously,
That-
that's question is that on that merely because the prosecution fails to prove the motive or it's a very weak motive, that cannot be a ground to disbelieve the witnesses to the assault or direct evidence if their evidence is otherwise
Authorized
believed.
expert.
So that's all. So who is to argue the next matter that ends? Item 2, this is Devasis Panda.
So item 2, we are not prepared with that.
No, we are not prepared means we are to,
Not been able to.
no, it's all right,
Go.
but item number 3, I think it has to go to the some other bench. It's from my chamber, okay. Let's go to item number 3. This matter before some other bench in which one of us, Justice S.K. Sahu, is not.
We were appearing in item number 3.
Huh?
We are appearing in item number 3.
No, no, ମାନେ ମୋ ପାଖରେ
ବୁଝିଲି।
Mr. Shaktidhar Das was there in one item and he was telling that he is ready. I think he was also coming, I think some item, I think in the top of the, maybe either 4 or 4 is the Mr.
This item is item 9.
Oh.
So that's his item.
No, or after lunch, somebody is to be made ready. That is how we are asking you. We are not taking up right now, but after lunch, any of the council, if ready, please tell us, know that. What about Mr. Acharya in item number 4? Mr. Bhal, is it your brief or?
No, my lord, he was searching, he is perhaps ready, my lord, because I will be informed, because he was saying
That
Yeah,
day he had
yesterday-
some personal difficulty because
Yesterday he was saying that if your matter is completed, I will argue the case.
Because 2, he is not, he is taking for
inform you. I
adjournment,
will inform
and
Mr.
3 I cannot take, so 4 is obviously the next item. So
I will
just
intimate-
ask,
I will
after lunch,
intimate.
let him come. Okay? Or who is to argue the matter from the state side?
Court will also remind you.
No, upon argument karibe to. ठीक है? Just we want to know. Yeah. It is old appeals. We can pass a general order that up to, let us say, 2005, these criminal appeals which are pending, you just take instruction either whether they are alive or not, and whether they have been prematurely released or not. These two important, because we have already talked with the DG police. He said that if that information comes up, then on all the matters, we can give that information beforehand to the State Council through the Airline Advocate General, so that that would not be a ground to again adjourn the matter and keep it for some other day waiting that. So
And you also may direct the office also to prepare the paperwork and supplement.
which one?
Most of the cases
Most of the cases paperwork important.
Paper ହେଇନି?
କିଛି case paperwork
ନା ନା।
21 ଟା premature release ହେଇଛି।
single bench rose.
ହଁ ଯେଟା ଦେଇଦିଅ।
Single bench matter ଗୁଡାରେ ହଉନି paperwork.
ହଁ division ରେ ହେଇଯାଉଛି
21.
prematurely.
21, the application file in the disposal for. Yeah, that's your. Criminal appeal number 328. କେତେ ଜଣ appellant ଆଦେହରେ ଅଛନ୍ତି? Oh, one appellant. With reference to state that conviction legal as so and so is confined to jail so and so
ଏଟା
here.
ଦୁଇଟା ସିଆରେ ପରା
ଆଉ ଜଣେ ଆଗରୁ ଯାଇଥିଲା।
ଆଗରୁ ଯାଇଛି
ଅର୍ଡର ଡେଟେଡ୍
29/4/2025 8 ରେ 218 ରେ ଆଗରୁ ଗୋଟେ ଯାଇଛି
ସିରିୟଲ ନମ୍ବର 28
ନା ମାନେ ଏଟା ୱିଥ୍ ଅଛି ଦିଟା
182/2001।
ହଁ ସେଇଟା ତ
ହଁ
ସେଇଟା 218 ସେଇ ଟାଇପର ଅର୍ଡର ପାସ୍ ହେଇଛି ବଟ୍ ଆଜି ସେମାନେ ଆଣିଲେ
ଏଟା ହଉଛି ଇଏରେ
ସେଟା ହଉଛି ରାଜା ପାଇଁ ଫାଇଲ
228 ରେ
220
ହଁ
200 ନାଇଁ ଆର ଯୋଉ
ନାଇଁ,
କନେକ୍ଟେଡ ମ୍ୟାଟର 218 ଟା 218 ଟା ଅଲରେଡି ସେଇ ଟାଇପର ଅର୍ଡର ହେଇଯାଇଛି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଇଛି that he has been prematurely released ଫାଇଲ ନା 200
କ୍ରିମିନାଲ ଏପିଲ୍ 228 of 2000
ଏଇଟା ତ ବର୍ତ୍ତମାନ ଅଛି ତା ସାଙ୍ଗରେ ଯୋଉଟା ଅଛି 218 ଟା
218 ଏଟା ସରିଯାଇଛି
ଏଇଥିରେ
ଏବେ ନେଇକି ଅଛି
218 ଟା ଦେଖିଲେ
Right.
ଅର୍ଡର ଟା
ହଁ।
ପ୍ଲିଜ ଫାଇଣ୍ଡ ଆଉଟ୍ ଦି ଅର୍ଡର ଏଇ 218 ଅର୍ଡର ଟା 29/4/2025
The senior superintendent circle general order which indicates that the appellant has been released prematurely on 28 there.
ସେଇ ମର୍ଡର ହବ ଆଦିର ଏଟା ବୁଝିଲାନି କ୍ରିମିନାଲ ଅପିଲ 218/2001 ରେ ଯୋଉ ଅର୍ଡର ହେଇଛି 29/4/2025 ରେ ସେଇ ଟାଇପ ଅର୍ଡର ଏଠି ହବ ଏବଂ ଇନଫର୍ମେସନ ଆସିଛି ସେମ୍ ତ ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସର୍କଲ ଜେଲ ଏଟା ଆସିଛି ଆଉ ସେ ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ହେଇଛି କେବେ ହେଇଛି reference to direct to ଏଟା 24/5/2013 ର ଲେଟର
9/4/13 ବୋଲି ହବ 9/4/13
ଆଚ୍ଛା 9/4 ଠିକ ଅଛି এটা କରିଦେଇକି dispose of କରିଦେବେ ଏଇଟା ଆଉ ଏଇ ଲାଇନ୍ ଟା ରଖିବ if the appellant intends to ଯାହା ତା ଦେହରେ ଲେଖା ହେଇଛି ସେଟା ରଖିବ ନିଅ so ଏଇ ସବୁ dispose of ହେଇଗଲା so we'll pass that order after lunch କଣ ହେଲା ମିଷ୍ଟର
Ready ହେଲା କି?
ନାଇଁ
It is my father's Shraddha. I am the midst of Shraddha, but I am informed. So I am not come to court. I am ready with the matter. If your lordship will permit me, I will do it day after tomorrow because I am in the midst of Shraddha.
no it's all right
I am ready tomorrow, day after tomorrow, I will
no
come to the
tomorrow
court.
no day after tomorrow ତ ଅଛି ଏଇଟା all right you may go and do the
Yes, obliged, madam.
ଆଉ କିଛି ମିଷ୍ଟର ଆମେ କହିଲୁ ନା ଶକ୍ତିଧର ଦାସ ଆସି ବସିଥିଲେ ତାଙ୍କୁ
No, he was in one of the appeal, in item 9.
କୋଉଟା
Item 9 ର ଗୋଟେ appeal ରେ ସେଥିଲେ CRA 5 of 2000.
ଆର୍ଗୁମେଣ୍ଟ କରିଦେଲେ ଆରଟାରେ ନଥିଲେ ବି
ହଁ, ଆମେ
ମ୍ୟାନେଜ
କରିଦେବୁ।
କରିଦେଇଥାନ୍ତେ ଆଉ ମାଇକ ସ୍ପିଡ୍ କହୁନି ସେନେଟର ବହୁତ
ଏଇଟା ଖାଲି କରିଦେବି।
छह जन आइटम 4 6 जन अच्छा 2 जन मरी 1 in 6 is dead.
That reports come that status report flag why
those two appellants are concerned, and it has been further observed that the appeal shall now remain confined to appellant number 2 to 5. When we made a query to the London Council for the state,
IAC data is 24th January.
next about the other appellant. What is the latest information about the
2, 3 and 4.
about the well-being of 2, 3, 4 and 5 na? Out. एक या 6 पर हम बोलिए ना
2, 3, 4.
2, 3, 4, 5. 2, 3, 4, 5. He submits that he may be given some time to obtain instruction in that respect. Stop. Since this court, this bench is taking of old criminal appeals, and in most of the appeals, the London Council for the appellant are expressing difficulty in ascertaining whether the appellants are alive or dead. And for
prematurely.
and
prematurely.
also for premature release, and for the same adjournments are being granted to the London State Council, which is delaying the disposal of the criminal appeals. Let all the division bench criminal appeals
Till
2005, in 2005, instruction be obtained by the London State Council. Instruction be obtained by the registry, by the registry to the Director General of Police as to whether the appellants in those appeals are
What the well-being of
about the well-being of the appellants,
as well as
as well as premature release, if any, got them. Stop. For such purpose, the file be placed before the registered judicial.
Registered judicial
Registered judicial
to take further
to
instruction.
take further instruction from the Honorable Chief Justice and
Please.
obtain
Place the information before this court
and place the information before this court
in each case.
in each case. स्थिति को देगी नहीं पड़ देगी ना पैसा जनरल फर्दर
Yes, about register registry place करियो office note देखिए office में जो register judicial up to date.
And the report should be, the report may be sent to the registered judicial.
No. Office will send to register judicial. That is a process. It will be placed before chief justice
Because
and
the
order will be
report has come from the advocate general office, but
No, it's all right. In addition to
Copy will go.
they are not
copy
tagging
will
the
go.
copy. They are not tag the copy in the
No,
file.
it's all right.
So,
But
if the-
let it will be a general manner. Let up to 2005 in all the case division bench cases, the instruction be obtained. So that would not be.
ଏବେ କଣ ଆପଣ ଆଇଏସି କୁ ମାଗୁଛନ୍ତି ସେ ଦଉଛି ନ ଦଉଛି କିଛି ନାହିଁ. Now that common order
ସେ ଯୋଉ ମେଲ ରେ ପଠଉଛନ୍ତି ସେମାନେ କମ୍ପ୍ୟୁଟର ସେକ୍ସନ ବାଲା ମଧ୍ୟ ତାକୁ ବାହାର କରିକି ଦଉନାହାନ୍ତି ଯୋଉଟା କି ଆମେ ହ୍ୱାଟ୍ସଆପ ରେ ମଗେଇକିରି
ନାଇଁ ସେ ତ ଅଲଗା କଥା ତାପରେ ଏଇ କେସ୍ ଦେଖୁନାହାନ୍ତି ଆପଣ ଯୋଉ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଆସିଛି ସେଟା ଅଗଷ୍ଟର
24
ହଁ ତେଣୁ ଅଗଷ୍ଟ 2024 so now almost 11 months have passed and we do not know about 2, 3, 4, 5 ହଁ ତେଣୁ ୟା ଭିତରେ ମାନେ 30 ବର୍ଷ ପାଖାପାଖି ହେଇଗଲାଣି ତେଣୁ
premature
ବେଲେ ବି ଯଦି ଥିବେ କଣ ହେଇଥିବ ଦେଖିବେ ତାପରେ ଆପଣ
ବେଲ ରେ ଯାଇଥିଲେ ଆଗରୁ
ବେଲରେ ଯାଇଥିଲେ
କାରଣ ଆବେଟମେଣ୍ଟ ହେଇଛି 2 ଜଣ ପାଇଁ 1 ଆଉ
1 and 6.
so let it be yes
I may be pardon, I have a small prayer. In item 2, a report may be also called for because instead of writing unlimited letters.
and এইটা তো জেনারেল অর্ডার ହେଇଗଲା
that includes
that includes every all the criminal appeals which are pending or division bench that report will come.
Item 22, my lords, that is, name is reflected of Mr. B. Panda, that your lordship will kindly have a glance while order dated, lords, amicus curiae has been appointed. His name is not in finding place in the list.
Which one
22, item number 22,
Just a minute.
you will kindly find order dated 15/5/2024. An amicus curiae has been appointed, his name does not find place on the list.
22 ର ଦିଟା appeal ଅଛି
First, again, 238,
238
again, order dated 15/5/2024.
Mr. Somnath Satpathy, learned counsel for the appellant in CRL such as praise for grant of time to get ready.
अच्छा
For a time.
we appoint B.S. Raiguru as amicus curiae
Again, ତାଙ୍କ ନାଁଟା ଟିକେ
from
ଆସୁନି, so
behalf
I
of
was
appellant
confused.
Madhav alias
Private brief.
No, it was late Mr. Ramanand Panda's brief. I was confused with the.
no now he has been engaged
Yeah,
that-
so his name may be
Yes,
reflected, so there is no more
oh,
confusion
it
with
is
my
not
own.
been reflected अच्छा
Acha.
okay it will let me do item number 22 it appears that as per order dated 15/5/2024 Mr. B.S. Raiguru has been appointed as amicus curiae to argue the appeal on behalf of the appellant. However, his name has not been mentioned in the cause list. Let the name of the learned amicus curiae be reflected in the cause list in place of Mr. B. Panda and his associates. है ना? Ethically कर देगा वो.
I would beg apology. Item 2, I will be ready by Thursday, my lords.
No, that's all right. ସେ ଯୋଉ ଜେଲ୍ କ୍ରିମିନାଲ ଅପିଲ ଗୁଡାକ ଅଛି ଆମେ ଏଗୁଡାକ 2005 ପର୍ଯ୍ୟନ୍ତ ଆମେ ମଗଉଛୁ ବଟ୍ ଫ୍ରମ୍ ୟୁର ସାଇଡ୍ ୟୁ ଡୁ ଇଟ୍ 2007 ର ଅପିଲ ଗୁଡା ଦେଖନ୍ତୁ ଆଇଟମ ନମ୍ବର 26 ପରେ 2025 ଟା ବି ହଁ 25 ଟା ବି ହଉଛି 2007 ର ତ 25 ପରଠୁ 2007 ର ଅପିଲ ତା ଦେହରେ ବି ଏଗୁଡାକ ମଗେଇ ଦିଅନ୍ତୁ ଆପଣଙ୍କର ଯୋଉ ଯେତିକି ହେଇଛି ଆଇଦର ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ କି ହଉ କି ସେ ତାଙ୍କର ୱେଲବିଙ୍ଗ ବଞ୍ଚିଛନ୍ତି କି ନାହିଁ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଯାଆନ୍ତୁ